For that reason, Chair, the evidence of Transnet will be presented in two phases. The first phase, which will take up approximately 13 witnesses over the ensuing weeks, will cover a limited range of topics, most if not all of which have been the subject of intensive forensic investigation to date. You will hear of the Waxman's report or reports, you will hear of the MNS reports, and there are several MNS reports, and you will hear, for example, of the Fundudzi report and others. And Ms. Sello will give a more complete picture of the nature and extent of those reports and the extent to which there are matters yet to be identified and investigated, and matters which have already been identified but must still be investigated. And what is important, Chair, to note, and this will be raised with witnesses in the next few days, in the next few weeks, is that Transnet has selected and prioritized topics for investigation, large value transactions. The investigation to that extent, or the investigations to that extent, have been internally controlled. They are not externally controlled. And in fact, time constraints that the Commission is obliged to abide by will limit the nature and extent of the investigations that Transnet can present within the lifespan of the Commission, and will limit the nature of the investigations, in fact, that the Commission itself can undertake. Page 3. Transnet SOC Limited, Chair, is a public company, and it's established in terms of the legal succession to the South African Transport Services Act of 1989, which has undergone several amendments, obviously, since that date. It's a state-owned entity with the government as the sole shareholder, and that shareholder is represented by the Minister of Public Enterprises. Transnet is not only a freight transport company, it is the custodian of the railways, the ports, and importantly pipeline networks, and we'll talk about pipeline networks in due course. It's the largest freight and logistics company in South Africa, and it connects various industries such as mining, manufacturing, distribution, import and export of goods and commodities. So it's an integrated freight transport company. And when one talks of logistics, one is talking about the detailed organization and implementation of quite a complex operation. It is the management of the flow or movement of goods, including commodities, between a point, usually a point of origin, and a point of consumption or export in order to meet customer requirements. It's far more than just moving of goods. It's the organization, the logistics dealing with those goods, and the management of imports and exports. It's comparable in asset size to some of the top 10 listed Johannesburg Stock Exchange companies. It has approximately 51,000 employees and a capital base of 380 billion rand. It's a crucial component of the South African economy. It stimulates economic growth, or ought to stimulate economic growth through employment, investment in capital projects, and social upliftment. It is the repository of vast amounts of taxpayers' money. Transnet has 5 operating divisions, and they are supported by a corporate center which is at present headquartered in Waterfall Estate, Midrand, no longer in Parktown. That move itself may be the subject of investigation, but enough said for the present, Chair. There are 5 operating divisions, as we've said. There's Transnet Freight Rail, Transnet Rail Engineering, Transnet National Ports Authority, Transnet Port Terminals, and Transnet Pipelines. To deal first with Transnet Freight Rail, this is the largest operating division within Transnet, and as far as the public is concerned, the division which defines Transnet in the public eye. It operates and maintains an extensive rail network across South Africa and connects with other rail networks in the sub-Saharan region. So it operates approximately 22,000 kilometers of rail track across South Africa. It itself, as a division, employs approximately 28,000 people, and it was able to generate in 2018 approximately 43.7 billion rand in revenue. The next slide will give an indication of some of the logistics which will be relevant and evidence to come. If one looks at the diagram on the right-hand side, you will see the coal line export from Mpumalanga to Richards Bay, which is a, to put it mildly, very busy freight line, and is the subject matter of some investigation in relation to the purchase of locomotives to service that line. And then on the left-hand side of that map, one will see from Sishen at the top of the orange line to Saldanha, there, Chair, the red line, which is the iron ore export line. Now, both of those lines require specialized locomotives in order optimally to facilitate the export of vast tonnages of coal and iron ore. So, for example, in 2018, Transnet Freight Rail transported 77 metric tons of coal, 77 million, I think that should be. I'll correct that, Chair. It's not 77 metric tons, 77 million metric tons of coal, and a lesser but significant amount of metric tons of iron ore on the export iron ore line. Those should be millions. So the principal lines that are important, Chair, for the purposes of evidence to come will be the export iron ore line, the export coal line from Mpumalanga to Richards Bay, the iron ore line from Sishen to Saldanha, and locomotives were also purchased for general freight purposes, and that is the spider web of rail connections that you see in the map as a whole. We can go to page 8. One of the biggest Transnet capital expenditure projects, amounting to 54 billion rand, that's 1/6 of the total assets of Transnet, was the acquisition of firstly 95, then 100, then 1064 locomotives. Those locomotives included electric and diesel locomotives for use on the heavy haul lines, that's the coal export line and the iron ore export line, and the general freight routes, which you've seen on the map in the preceding slide. The evidence to be led will cover procurement irregularities, significant procurement irregularities, alleged fraud and corruption relating to the procurement of these locomotives and payment therefor. This aspect of the evidence has been subject to detailed forensic reports, which will be summarized and presented to you, Chair. but the extent of the alleged corruption there runs into billions of rand. If we may move on then to Transnet Engineering, which also plays a role in the issues relating to the purchase and payment for locomotives. It's the advanced manufacturing division of Transnet. Its core business includes engineering, manufacturing, assembly of locomotives, and the assembly of the 1064 locomotives is relevant here, maintenance services for the rail industry locally and globally. Transnet Engineering manufactures and remanufactures locomotives, freight wagons, and passenger coaches. It also assembles locomotives, parts of which are manufactured abroad. And it also maintains and services related products. The alleged corruption, which is the subject matter of the various reports in relation to the purchase of electric and diesel locomotives, involved, amongst others, and this evidence will be presented to you in the course of the next week or so, Chair, senior Transnet executives and board members, importantly financial advisors, and international suppliers acting in collusion. If we may go to page 10, Transnet Engineering operates 6 main establishments, really. They're something perhaps different from just factories, situated in major city centers throughout South Africa. And there will be evidence in relation to the locomotive issues of a so-called relocation of the manufacturing processes to be conducted by 2 locomotive manufacturers, China North Rail and Bombardier, to the Durban factory of Transnet Engineering. The initial costs for that so-called relocation, it was really establishment, was estimated to be 9.7 million rand, at least as concerned China North Rail. Those costs escalated astronomically to total approximately 1.2 billion. And the entity BEX, which calculated those inflated costs, or allegedly inflated costs, from an original estimated 9.7 million rand to 647 million rand for China North Rail. There was a similar cost for Bombardier. That entity was paid 67 million rand for its troubles. Now, there are 2 issues in relation to this issue. It's a complex issue, and it will involve complex evidence. But in very broad summary, the question arises whether any cost should have been incurred at all, or whether the cost of establishing, not relocating strictly speaking, but establishing a manufacturing base in Durban should have been part of the overall tender price. But even if it was an extra justifying a variation to the original contract, the prima facie evidence and the actual evidence which you will hear will show that the cost of 1.2 billion rand was just an enormously unjustifiable and hugely inflated cost, which should not have been incurred at all. And in fact, the recommendation has been to date that payments in respect of that so-called relocation should stop. So it's not as if and terminology here too is important. Relocation assumes that there's an existing manufacturing operation in one location, and that manufacturing operation is lifted up and moved and placed in another manufacturing operation. That didn't happen. It was merely the establishment of manufacturing operations or assembly operations for the locomotives that were managed under the various contracts that will be discussed in due course. So the ultimate costs that we're talking about here are in excess of 640 million rand for relocation or plant establishment for China North Rail on the one hand, and a similar amount in excess of 600 million rand for Bombardier. The contract for the manufacture of 1064 locomotives was established after tender processes with 4 original equipment manufacturers: Bombardier, China North Rail, China South Rail, and General Electric. Only 2 of those are involved in the so-called relocation issue. If we may move then to page 11. Part of the Transnet establishment is the Transnet National Ports Authority. You will see in the right-hand side of that slide, Chair, a diagram showing the location of the ports under the control of the Transnet National Ports Authority. They are Richards Bay, eThekwini or Durban, East London, Gura, Port Elizabeth, Mossel Bay, Cape Town, Saldanha Bay, and a largely inactive operation at Port Nolloth. Transnet controls the land within all the ports and has a role as the planner to improve, develop, and maintain port infrastructure. It also is responsible for the provision of port services and facilities, and may obviously enter into agreements with or license other parties to provide services at those various ports. It makes and applies rules that control navigation within the limits of the South African ports and the approaches to them, and its mandate is to provide safe and secure ports and to protect the environment within port limits. Transnet National Ports Authority employs approximately 4,178 persons, controls 9 national ports around South Africa. There will be evidence led in relation to one particular project undertaken under the auspices of Transnet National Ports Authority. The allegations are that there were irregularities and corruption relating to the procurement of CCTV security cameras from an entity called Neotel, which was a project intended to upgrade security in the national ports controlled by Transnet National Ports Authority. Then there is a related division, but a separate division within Transnet, and that's Transnet Port Terminals. So whilst the Port Authority, or the Ports Authority, is responsible for the maintenance and development of the ports, the physical ports themselves, the logistics in relation to freight at the ports and from the ports and to the ports is controlled under the auspices of the port terminals. So the Transnet Port Terminals, a separate division, but related, as we've said, is responsible for commercial services relating to freight, including imports, exports, transshipments and containers, as well as automotive parts and vehicles. It services a range of customers. They include the general shipping industry, which in turn use the ports. They include vehicle manufacturers for import of parts and export of vehicles, agriculture, the steel industry, the mining industry, freight forwarders, and cargo agencies. And the Port Terminals division has a staff complement of over 7,000 persons. An important component of Port Terminals infrastructure and capital base are, as one will know if one's ever been to a port, the cranes that operate the loading and unloading of freight onto and off ships. There are allegations of fraud and corruption in relation to the acquisition of ship-to-shore cranes from entities styled ZPMC and LIBA. And again, vast amounts of alleged money wasted in essence are involved. This matter is still under investigations and will form the subject matter of phase 2 of the evidence, or part of phase 2 of the evidence to be led before you, Chair. If we may move then to the next final division of Transnet, that is Transnet Pipelines. The importance of the pipelines division to the economy of South Africa, Chair, is often not foremost in the public eye. But Transnet Pipelines is a vital part of the economic network servicing South Africa. Transnet Pipelines operates, manages, and maintains 3,800 kilometers of a high-pressure underground petroleum and gas pipeline network in South Africa. Its extent can be seen in the map on the right-hand side of that slide. It essentially operates from KwaZulu-Natal to Gauteng, the economic hub Gauteng, and there are various offshoots and off-take stations along the way. And its importance strategically to the economy of the country, Chair, is that it is central and critical in maintaining a reliable, continuous, and efficient supply of crude and refined products, oil and gas, to industry and to the public at large. It is a vast operation, Chair. It's a multi-purpose pipeline. In other words, it is able to transport various goods in large volumes over long distances. It's buried well underground, and it covers a distance of over 550 kilometers. As stated, it's designed to transport liquid petroleum fuel from Durban to Gauteng and neighboring regions. It is able to transport 2 diesel grades and 2 unleaded petrol grades, as well as jet fuel from Durban to Gauteng. The next slide is just anecdotal, Chair. It is a factual collation of statistics in relation to the extent of the Transnet Pipelines operation. Apologies for the spelling error in the heading there, Chair. But it is able to transport 1 million liters of fuel per hour through its pipeline operation. Its structure and manufacture is vast. A number of detailed issues had to be attended to in its construction: river crossings, wetland crossings, and the like. It ranks amongst the largest multi-product pipelines in the world. Importantly, Chair, and this is a matter that is perhaps a matter that ought to be looked at, but we don't have direct evidence at present. It was initially forecast to cost about 12.7 billion rand. Perhaps not unsurprisingly and predictably, Transnet has spent by 2017 approximately 30.4 billion rand, almost, well, 2.5 times the initial cost. And costs are apparently increasing continuously as time goes by. There have been allegations of fraud and corruption, and these are the subject of investigation. May deal at page 21. Thanks. Chair, this section of the opening will deal with general allegations at quite a high level of summary in regard to the investigations and reports of state capture, fraud and corruption within Transnet. The allegations of corruption at Transnet, and where this Commission will ask its questions, present its evidence, and make submissions to you, Chair, in regard to possible findings that you can make ultimately, center largely on procurement. These include questionable transactions for port cranes, locomotives, IT services, and also importantly, Chair, advisory financial management and consulting services. You will hear in due course, Chair, of the existence at Transnet of a capable, highly skilled and well populated Treasury Department, which was at a stage completely sidelined in favor of external advisory financial management and consulting services at huge cost to Transnet and the taxpayer. Many of the contracts which will be examined, Chair, were awarded by confinement, that is, without an open tender. And the allegations that will be examined concern allegations of kickbacks to front companies related, amongst others, to members of the Gupta family. And these were paid often under the guise of promoting BEE or empowerment partners. Those are the allegations that will be examined, and those are the allegations which in the evidence will be questioned and testified to. What is important about these deals, in addition, of course, to the loss or the alleged loss of finances and money to the tune of billions of rand, is that accompanying these allegations or these circumstances which form the subject matter of the allegations of corruption is an ongoing systematic weakening of the governance structures within Transnet. I've mentioned but one example of the sidelining of a perfectly competent, well-regarded treasury function within Transnet. There will be evidence of appointments to boards that were inappropriate. There will also be evidence of the centralization of procurement functions, decision-making powers within Transnet. And that evidence will be given in due course. One example I will deal with in a moment. So on page 23, we highlight some of the implications of what has happened in the past decade or so within Transnet. Firstly, the situation, or the direness of the situation within Transnet, has been compounded significantly by the outsourcing of internal treasury, audit, enterprise data management, and other corporate functions to a related network of private firms with corrupt or allegedly corrupt interests. So what has happened is that rather than perform the functions internally through outsourcing, and in some cases unnecessary outsourcing, the evidence will be of, for example, treasury functions, a set of relationships was created which enabled corrupt activities or alleged corrupt activities to take place. You will hear evidence.
I'm sorry, Mr. Pretorius, you referred a minute ago to the centralization of power in Transnet, including hiring and procurement powers.
Yes.
You may need to flag that so that in due course somebody could just go back to Ms. Pumla Williams' evidence in terms of what happened at GCIS and see whether what she said happened there is in any way compared to the centralization of power in relation to procurement here.
Once
that will be talked about.
Yes, Chair. Of course, once, and this is a central function of this Commission's inquiry, is to detect whether there are patterns which indicate a degree of organization rather than just random and disconnected acts of alleged corruption, and we will certainly do that.
Yes, because I do recall that she alleged that after Mr. Mzwanele Manyi had been appointed as head of GCIS, he changed, made certain changes which ensured that the power relating to procurement was centralized, if I'm not mistaken, but I'm
well,
not
that's
sure.
precisely what happened, and I'll come to the detail, or at least to some extent to the detail in due course. But
thank you.
Two things happened really within Transnet is that a special committee at board level was established under particular designated personnel about whom allegations of corruption abound at board level. That's the BADC, the Board Acquisition and Disposals Committee. At the same time, the divisions within Transnet, the 5 divisions about which we've spoken, were disempowered in relation to procurement, so that all decisions relating to procurement could be made by, in essence, a few individuals. And the allegations is that they were, quote unquote, captured, Chair. You will hear in a moment, Chair, of a massive capital expenditure project involving billions, hundreds of billions of rand. And within those projects, costs burgeoned over a period of time. And it's arguable, and the question will be asked, whether that increase in costs over a period of time within the various projects, for example, on the so-called relocation from an initial 9 million to less than 100 million to 1.2 billion, from Locomotive's 38 billion to over 50 billion, whether those increases of costs were connected to attempts for private gain. And the conclusion which will be examined is these events which will be examined in evidence, Chair. The question must be asked, the important functions that Transnet must perform for the economy of South Africa, has its ability to perform those functions ultimately been weakened, or has it been enhanced? And there will be evidence to show that the former is the case, but it is a question at this stage that will be posed. There's no doubt, Chair, that money has been lost. The circumstances and the elements of fault and organization are matters for investigation. Vast amounts of money have been lost. So there's no doubt that the finances have been affected. But there's also the important consequence of the weakening of Transnet as an institution in its capacity and ability to deliver on what is its important function for the economy of the country. So one matter that will be examined over the period of the evidence to be presented, and a matter that will concern you, Chair, is what governance and structural reforms might be necessary to ensure that Transnet and other state-owned entities are able to perform their function within the South African economy. Because the allegation is that Transnet has been abused, its structures have been weakened in order to facilitate the export of billions and billions of rand offshore to parties who certainly should not have enjoyed that benefit. Chair, on page 25 of the slides, we deal with some changes in governance and executive management within Transnet from May 2009 onwards. At this stage, apart from certain comments that I will make in a moment, we seek to draw no conclusions, certainly seek to draw no final conclusions at this stage in relation to appointments and dismissals, merely to record that they occurred, to highlight the presence and position of certain individuals within these changing structures, and to ask the question as to whether these appointments and dismissals were somehow related organizationally and functionally to the series of alleged corrupt acts that followed and the money flows which occurred as a result. Between May 2009 and October 2010, the Department of Public Enterprises minister concerned was Ms. Barbara Hogan, who has given evidence before you, Chair. And on page 25, you have the persons involved in the ministry assisting her in that function. She's given evidence about the circumstances which she confronted whilst she was Minister of Public Enterprises, the events, the relationships, and their outcome for her position as Minister of Public Enterprises. If I may then go through to page 26, one will see there the acting Chief Financial Officer, who interestingly was appointed a week or so after the resignation of Ms. Maria Ramos from Transnet in 2009 as acting Chief Financial Officer. He will feature largely in the evidence that will be given. In November 2010, Minister Gigaba was appointed as the Minister of Public Enterprises, and that appointment, and that's at page 27, brought about significant changes in governance and executive management within Transnet. So, for example, one report to which you will be referred in due course puts it as follows. The word repurposing arises, and that word in this report broadly means the appointment in governance and executive management of a particular state-owned entities in order to direct its activities towards illegal gain. In other words, the question that this commission will ask is whether this repurposing took place. In other words, whether these dismissals, whether these appointments were directly intended to further the project of state capture, corruption, and fraud. One of the reports puts it as follows, and of course the sentiments expressed, which I'm about to quote now, will be the subject of evidence and investigation. So at the moment we put it as a question for investigation. The report states this repurposing began with the appointments of boards and executives. Minister of Public Enterprises Barbara Hogan resisted this emerging undue influence on appointments, which likely accounted for her dismissals only 18 months after her appointment. Malusi Gigaba replaced her as Minister of Public Enterprises in November 2010. While he was an early vocal supporter of using procurement budgets of state-owned entities to pursue economic transformation, often the result was to unduly benefit elites, including local politicians, wealthy international corporates, and a foreign family that would become billionaires as a result. Starting with the new board headed by Mafika Mkhwanazi, who has admitted to a personal relationship with the Gupta family, there would go on to be many individuals with ties to the Guptas who would be appointed to Transnet's board and executive team. The allegation in that report, in summary, Chair, is that these appointments from a ministerial to an executive level were designed to and influenced by external interests. That is the allegation that will be the subject matter of interrogation in the evidence to follow. Certainly as far as the nature and purpose of government and executive changes commencing in November 2010. At page 28, one will see the executive changes that happened under the watch of Minister Gigaba. We have mentioned Mr. Mkhwanazi, who was the chairman of the board of directors between 2011 and 2014. Importantly, and a name that will feature prominently in the evidence over the next 2 weeks, is the appointment of Mr. Brian Molefe as Group Chief Executive in 2011. What is interesting as a feature about that appointment is that it was forecast in the New Age newspaper 3 months before it actually occurred. In relation to his particular appointment and the processes followed, there has been a great deal of controversy, and evidence will in due course be led concerning how Mr. Molefe came to be appointed, the processes followed in his appointment, and whether these were proper, to put it bluntly, or not. It was on the 7th of December 2010, about 3 months before his appointment, the New Age, without quoting its sources, said, "The New Age has it on good authority that Molefe will be appointed CEO by the board." That newspaper correctly predicted other appointments to the new Transnet board, including that of the chairperson, Mr. Makhonazi, chairman of the Board Acquisitions and Development Committee, Mr. Makhonazi, is different from the chairman of the board. One will see that the executive management under the watch of Mr. Gagaba included Mr. Molefe, Mr. Anoj Singh, who was appointed permanently as Chief Financial Officer in 2010, Mr. Don Mkhwanazi, who was Chairman of the Board Acquisitions and Development Committee. That is the Procurement Committee that I spoke of earlier, Chair, that was centralized and wielded enormous decision-making powers in relation to the vast procurement projects that took place. And then Mr. Iqbal Sharma succeeded him as chair, and you will hear of him in due course. In fact, we are informed, Chair, that it was Mr. Iqbal Sharma that nominated Brian Molefe for appointment as General Chief Executive or Group Chief Executive. And you will learn in due course that Mr. Sharma played a central role as chairperson of the BADC. Mr. Sharma, as chairperson of Transnet's Board Acquisition and Disposal Committee, and Mr. Esser were business associates. And the evidence is that certainly Mr. Esser, or a company in which Mr. Esser was involved, a company called Tequesta, you will hear that's T-E-Q-U-E-S-T-A, benefited enormously from what the reports allege is quite an improper deal to the extent of tens of millions of rands. If I may just mention that it was under the watch of Mr. Singh as General Chief Financial Officer that the contract in relation to the 1064 locomotives ballooned, it is alleged in the reports unjustifiably, from an amount of 38.6 billion rand to well over 50 billion rand. Then over the page, on page 29, Chair, Minister Lynn Brown was appointed as Minister of the Department of Public Enterprises in May 2014. On page 29, one can see those in the department who were mandated with the task of her ministry and its functions. On page 30, one will see the changes in executive management. You will hear evidence in relation to the Group Chief Executive, Mr. Siyabonga Gama, Mr. Gary Peter, the Chief Financial Officer, the Group Treasurer, Mr. Ramo Sabudi, and the Chairman of the BADC, Mr. Stanley Shane. They will all feature prominently in evidence to be given. The evidence will be that all the persons that I've named, who, apart from Mr. Anoj Singh, came onto the scene under the watches, respectively, of Minister Gagaba and Minister Brown, played a significant role as senior executives in the circumstances which have given rise to the allegations and to the findings of corruption in the various reports. I may just mention, Chair, a relevant section of the governing legislation, which is a matter that perhaps bears interrogation. It's the legal succession to the South African Transport Services Act, Section 17, which gives the minister responsible powers, but clearly also concomitant duties. It reads, without in any way derogating from the provisions of Section 15, should the company, that is Transnet, act in a manner contrary to the strategic or economic interests of the Republic of South Africa, the Minister may direct the company by means of a written notice or by any other means that he may deem desirable to discontinue such activity within a reasonable period, which shall be stipulated in the notice or other means of communication employed. And it may be an interesting part of our investigations to determine whether, and if so, which and when notices under that section were issued. Because one of the most important aspects of the investigations to date and in future will be the question of oversight, both ministerial and parliamentary. As you know, Chair, Parliament has, through its committees, already embarked upon investigations into state-owned entities. Just bear with me a moment, please, Chair. On page 31, at least one of the key changes in the manner in which Transnet was governed is highlighted. You will hear, Chair, of the establishment of the Board Acquisitions and Disposals Committee under the watch of Minister Gigaba and continued under the watch of Minister Brown. It is that committee that, as we've said, exercised vast decision-making powers in relation to procurement within Transnet. That procurement took place against the background of what is highlighted on page 32, and that is the market demand strategy of Transnet. Essential to that strategy, Chair, was rather than responding to customer demand or market demand, a decision was made on the part of Transnet to create demand, and I'll deal with that in due course. But for the moment, what is important is the allocation of 300 billion rand to capital expenditure, a fertile ground for what is alleged to have transpired and what is found to have transpired in the many reports which will be placed before you. The market demand strategy was an investment program well-intentioned to expand and modernize the country's rail, port, and pipeline infrastructure over a period of 7 years in order to promote economic growth in South Africa. Question will be asked is, has that result been achieved? So 300 billion rand was earmarked for a capital investment program. Immediate question may be posed, was that capital investment program properly utilized for the benefit of South Africans, or was it to some or even large degree money thrown away? The underlying intention was to increase the operations of Transnet, increase its capacity so that it could generate market demand, so that if there was an efficient export rail service, it would attract customers rather than merely meet existing demand. It was obviously aimed at maintaining financial stability and strength. It was aimed at productivity and operational efficiency. Important in the Transnet strategy was a desire to encourage a shift from road to rail. The benefit to the economy, the maintenance of the road framework, which is overburdened by freight at present, is obvious. Not only might that reduce the cost of doing business, the logistics of freight movement, but also would have a beneficial environmental effect. And most importantly, properly managed, the project would have enabled economic growth, job creation, skills development, localization of production, empowerment and transformation opportunities. And the question that is posed, Chair, is whether that market demand strategy and the related capital expenditure plan of well over 300 billion rand, albeit that it was clearly sound in its objectives and principles, whether that was exploited for the purposes of state capture, fraud and corruption, whether through the dismissals and appointments, the weakening of oversight and governance, the centralization of decision-making in regard to procurement, arguably in the wrong hands, has undermined a market demand strategy that arguably was for the great benefit of the country. And so the question will be asked was whether that program rendered Transnet, in short, a prime target for looting. So, Chair, on page 35, we say that during this first phase of evidence, approximately 13 witnesses will give evidence. That evidence will cover not only allegations but findings of procurement irregularities, fraud and corruption relating to a number of procurement categories of issue. Firstly, there are the contracts for the purchase of the 95, the 100 and the 1064 locomotives, contracts between Transnet and China South Rail as well as China North Rail. There will be evidence of the appointments of financial advisors, McKinsey, Regiments and Trillian, as advisors to Transnet. The nature of those relationships and the cost of those relationships to Transnet and ultimately the taxpayer, and importantly the propriety of those contracts. I've mentioned the so-called relocation of the locomotive manufacturing operations from Gauteng to KwaZulu-Natal, contracts and other transactions with T-Systems, contracts and other transactions with Neotel. On page 36, we highlight the nature of the evidence to be led in relation to the procurement of the 95 locomotives, contrary to procurement procedures and policies of Transnet. Also, the separate category of issue, the acquisition of 100 locomotives by confinement to China South Rail for 4.84 billion, which involved not only failure to comply with procurement procedures within Transnet, but unilateral changes to the business plan by senior executives and misrepresentations made to the board of Transnet. Then, in 2014, the massive procurement contract involving the manufacture and purchase of the 1064 locomotives. That is the contract that was split between 4 manufacturers: China South Rail, Bombardier, General Electric, and China North Rail. Some of the issues that will be discussed is that these manufacturers or original equipment manufacturers were obliged to source up to 60% of their components from South African subcontractors. This did not happen. This whole process was overseen by the Board Acquisitions and Disposal Committee. The costs, at page 38, of this operation increased significantly from 38 to 54 billion rand. Whether this was justifiable at all, whether increase in costs was permissible in terms of the original contractual arrangements, is a matter that will be raised and has been raised in the reports. But much of what occurred in the increase in costs was not so much the increase in costs of the equipment, or the original equipment and its assembly, but the financial dealings, the cross-border financial dealings, the interest rate swaps, very complex evidence that will be given, hopefully clearly by someone other than, or led by someone other than myself, Chair, in a way that can be understood. The relocation I've dealt with, the involvement of McKinsey regiments and Trillian as advisors, in which relationships were sourced, arguably the loss of billions of rands to Transnet as a result of the finances relating to payment for the deals. And what is of some concern potentially is why the Transnet Treasury Department was sidelined completely in this operation, when according to the evidence it was capable of doing the work that McKinsey regiments and Trillian were employed to do. There will be evidence, Chair, of tens of millions of rands paid to companies that did nothing for it, just simply paid, arguably just looted or stolen. Then on page 39, we deal with the Neotel contract. The entire digital communication network services was outsourced to Neotel during the period 2009 to 2019. As part of that operation, an amount of 300 million rand was spent in purchasing certain network equipment from Neotel under a master services agreement. 34 million rand was paid to an entity called Homex, again as a, quote, success fee, unquote, for facilitating that contract, which was worth, as we've said, 300 million rand. A new master service agreement was signed in 2014, which again resulted in payments being made to Homex, totaling amount of 41 million rand as a success fee. The question is not whether that was a payment of an amount of money in excess of what ought to have been paid, but whether it should have been paid at all. In other words, whether the amount of 34 million rand and 41 million rand was simply looted from the coffers of Transnet for no value whatsoever. That will be the question that will be asked. Similar to the over 70 million rand paid to Tequesta in relation to the 1064 locomotives deal, an entity in which Mr. Esser had an interest, and we know that Mr. Sharma and Mr. Esser were business associates. So, Chair, there are a number of transactions here where one is not only talking of payments that have involved the ballooning of manufacturing costs, but matters where the allegations have been, and the reports have shown, that no money should have been paid at all, and yet it seems that tens of millions of rands were in fact paid. And those are questions, the veracity of which and the allegations in relation to which will be examined in evidence over the next few weeks. Then, Chair, we have, in relation to T-Systems on page 40, allegations of the favouring of particular bidders who ought not to have been favoured in the awarding of contracts, and the intervention of the board in overruling the procurement processes and recommendations of the evaluation team, disregarding the business owner, that is the division from which the contract emerged, or for whom the services were to be rendered. And I've mentioned the disempowerment of the divisions and the business owners. That contract was ultimately set aside and declared irregular by the High Court. Chair, there are, as we have tried to stress, a number of other matters besides the matters already subject to the reports that appear to indicate that, notwithstanding the attempts of Transnet itself, of Parliament, and of independent investigators to uncover what happened in Transnet over the period of time that is the subject matter of the evidence that we've been mandated to place before you, Chair, whether there is not too a vast amount of unknown matters still to deal with and investigate. Whether we will have the capacity and the time to do so, certainly mechanisms should be in place to ensure that a complete and thorough investigation into all procurement within Transnet takes place, and that will be the subject of further investigation. But many reports, including Gupta Leaks, Chair, indicate the presence of other malfeasance besides that which we foreshadowed in this opening. Chair, I see it's 11:15.
Okay, we'll take the tea adjournment and we will resume at 11:30. We adjourn.
All right.
Stretched out to tea for you.
Yes, Mr. Pretorius.
Thank you, Chair. There are some housekeeping matters which we will deal with tomorrow morning that have arisen this morning. I needn't trouble you with them now, but for the present, Ms. Sello will present the gap analysis on existing reports to the matters relating to Transnet.
Okay, thank you. Ms. Sello.
Thank you, Chair, and thank you, Mr. Pretorius. Chair, with your leave, may I start by handing you two indices in a little pack? I am going to suggest that the Chair retain these two indices for the duration of the Transnet evidence. It will make reference to the various reports and volumes much easier. Thank you. You have, Chair, to your right, volumes of reports that are being submitted on behalf of Transnet.
To my left.
To your left, my right. My apologies, Chair. To your left, indeed.
There's nothing on to my right. Yes.
And Chair, just to point out a few things before I deal with the respective reports. There is a total of 17 separate documents. Combined, they run to 26,931 pages. We tried to think of a way to make them presentable to you without necessarily subjecting you to 26,000 pages. And we have come up with the following system, which we hope will meet with your approval. You have been provided with 16 of the 17, and I'll explain shortly why, reports, excluding their respective annexures. That's what makes the report so voluminous, except for the reports we call the MNS reports. The reason for that is that there will be evidence laid specifically on the MNS reports where the annexures during the course of the hearings become pivotal. What we have done instead is to provide you with a report and a list of all annexures relating to that report and what pages they would appear at, except that the annexures are provided electronically. Your volumes, as you currently have, therefore, Chair, would run from volume 1 to volume 17. This is excluding those annexures. If that meets with your approval, Chair, I suggest that we approach the matter in that way.
Yeah, that's fine, thank you.
Secondly, Chair, in the file that Mr. Pretorius handed you today, the Chair will realize that it is in 3 parts. The first part is the presentation that Mr. Pretorius has just given. The second part is what we call the executive summary of the gap analysis. And the third part is the full gap analysis. We have tried to create an executive summary for purposes of presentation today. Hard as we tried, we did not reduce it to as much as we had hoped we would be able to. The two indices I handed up to the Chair in a red folder, they relate to the main gap analysis, which is the third document in your folder. So the pages will correspond. What we have done for the executive summary is to paginate afresh the executive summary starting with page 1, and that is for ease of reference during presentation. We have not tampered with the original typed numbering of the document, which will correspond with the indexes I've given and with the main presentation. That way, the chair is able, should he so desire, and if he has made any notes on any page, to substitute page 5 or page 15 of the main presentation with the one he's made notes on. Thank you, Chair. Before I get into the respective reports, I need to point out that the reports that we present today do not purport to constitute a result of thorough investigation of all Transnet affairs. As we go through the report, the Chair will notice that each investigation had a specific scope and mandate, and at times there would at first blush appear to be overlaps and duplications. But as we go through the reports, the Chair will notice that what would appear as duplications or overlaps have got a rational explanation. If now the Chair would have regard to the executive summary, I will move, Chair, to page 5 of that executive summary. And just to give an overview of the gap analysis itself, and to indicate that there are 19 reports in total that we have deemed relevant to the affairs of Transnet. We have tried to classify them in a coherent fashion that would make it easier to follow. We have divided the presentation into 3, section A, B, and C, where section A are what we call reports by public organs and at times presentation by ESCOM to the portfolio committee. Section B are the forensic reports, the actual forensic reports following investigations. And section 3 just highlights certain relevant court cases that will be dealt with, or that will be covered in the course of testimony before you, Chair. Now, if I may then turn over to page 6 and deal with the first section, section A, which are reports by public organs. The first report at page 7 is just the front page of the Public Protector State of Capture report. This report is relevant for Transnet, but to avoid prolixity, we have not included it in this presentation because it has served before you already as Exhibit A. That will then take us to the second report, which is the Public Affairs Research Institute report, starting at page 9. This report was generated on 24th August 2018, following research conducted by the Public Affairs Research Institute, PARI for short. If the Chair would have regard to page 10, we explain at point 2 thereof the limitations of this report, and it states that the authors of this reference book have set out to provide an independent, accessible, concise, and fact-based account of some, but not all, of the alleged instances of governance failure and corruption at Transnet. On reading of the report, the limitations of the report are clear, and one understands specifically which alleged instances of governance failure have been dealt with in the report. At page 11, we list the specific transactions that the PARI report covers, and it's the 8 transactions that appear on the screen. Some of these transactions have also been considered by other investigators. The difference between what PARI did and what other investigators, how the other investigators conducted their investigations, is that PARI relied in the main on some of the Gupta leaks, emails, and documentation that was in the public domain already. As we deal further with these reports, we will deal with some of these transactions, such as the procurement of locomotives, Neotel regiments, T-systems, and the reports in respect of each one of them, further on in the report, are based on investigations of original documentation. To the extent, therefore, that there may be contradictions between the original investigation and the PARI report, the explanation is that the investigators used original documentation obtained from Transnet and other reliable sources. We express a view at page 12 whether, Chair, you can accept this report. And our view is that yes, you may, with the caveat that we might understand that it is based on the Gupta leaks not the entire HDDH record and publicly available information. With that qualifier, we submit that it may be admitted. We note that further investigations need to be conducted by the Commission itself to give credence or deal with some of the issues or findings that the PARI report have made with reference to their own material and the entire HDDH report. The second document, Chair, at page 13, is headed Portfolio Committee on Trade and Industry and Transnet and dated 12th February 2019. This, in fact, is a presentation made by Transnet to the Portfolio Committee on Trade and Industry, in essence, to give a report of steps it had taken following the various investigations into Transnet. And these are then listed at page 14, the steps thus far taken by Transnet, chief amongst which has been the institution of criminal cases where relevant, summons being issued to those employees who are suspected of wrongdoing in an attempt to recoup the monies lost to Transnet. And summons have also been issued to the companies Regiments Capital and Trillian, who were transaction advisors in what, as Mr. Pretorius has indicated, was the 1064 acquisition process. We list further on senior former Transnet officials who the reports have pointed to as having committed some irregularities, and summons have been issued to the people listed therein. At page 15 is a table that on its own wouldn't make much sense. The purpose of this table is to give a sense of the 1064 acquisition process, and notwithstanding its budgeted purchase price, that by March 2018, by December 2018, none of the contracts had been executed to the full. There are still a whole lot of outstanding deliveries, and these are some of the problems for Transnet as they continue to increase costs. These first then three documents, Chair, are what we call Section A, and they are to be found in Volume 1 of your report. If I then proceed to page 17, page 17 is the start of Section B, the forensic reports. And the first is at page 18, which is the Waxman's report, acquisition of 1064 locomotives. Page 19 reflects the mandate that was given to Waxman's by the Transnet board at the time. And this included inter alia to establish whether the processes followed in procuring the 1064 locomotives were in compliance with Transnet policies as procedures, as well as National Treasury regulations, to review and validate submissions made to the bid adjudication committee and the board in respect of the procurement of the 1064 locomotives, and to ascertain, amongst other things, the reason for the increase in the estimated total cost, to establish whether prices were inflated after hedging and determine whether escalations and contingencies were added. The mandate was broader than that, Chair. We just highlight the key issues that are addressed in this report. And at page 20, we reflect the conclusion. And the view is that the report is subject to limitations. It is apparent from the report that the report must be considered inconclusive. Waxman's was frustrated at every turn. It did not enjoy any cooperation from the management and board of Transnet at the time, and was denied access to relevant information. In the circumstances, it could not make any conclusive findings in respect of the mandates that I have referred to. The next report appears, before I get to the next report, the Waxman's report is the last of the reports in your volume 1, Chair. So that completes your volume 1. We then get to page 21. At page 21, we deal with reports prepared by MNS attorneys. MNS attorneys investigated and have submitted 6 separate forensic reports. Yes, Chair?
It may be a useful idea to have another copy of the index that you have given me
Yes, Chair.
that can be put at the beginning of these reports, which will tell me, without me having to look for this separate bundle, in which volume which report belongs.
We will do so, Chair.
Yeah.
We will do.
Okay.
Thank you, Chair.
All right.
Please make a note. I am now at page 21 and dealing with the MNS reports. There are a total of 6 forensic reports submitted by MNS attorneys. The first is the procurement of Transnet 1064 locomotives. The second concerns the alleged irregularities relating to the appointment of the transaction advisors in respect of the acquisition of the 1064 locomotive tender and financial transactions concluded pursuant thereto. In that respect, there are 2 separate volumes. The third was an investigation into the procurement by Transnet of 95 on the one hand and 100 locomotives. And the results are reflected in 2 separate volumes. And the last is the relocation of the manufacturers to Durban. Turning then to the procurement of the 1064 locomotives themselves. This report starts at page 22, dated October 2018. The mandate is reflected at page 23 of MNS. And the Chair would immediately realize that the mandate in large part corresponds with the mandate given to Waxman's. It was to investigate the same issues that Waxman's had investigated. The reason for this is, at the time of engagement of MNS, the whole investigation had to be redone. MNS enjoyed better access to the information held by Transnet, whereas Waxman's was not able to do so a year previously. So there may be 1 or 2 contradictions between the 2, but as we work through the MNS reports, through witnesses, it will become apparent why it is MNS arrives at a different conclusion, should that be the case, to the conclusion drawn by Waxman's on the same issue. So in the main, as far as 1064 is concerned, Mr. Pretorius brought to your attention, Chair, that insofar as the acquisition of 1064 is concerned, there was a significant increase in the cost of acquisition from 38 billion to 54 billion. MNS was to investigate the cause of that increase and to determine whether the reasons advanced for the increase were reasonable and justifiable. This is contained in the report, and MNS has drawn its conclusion. And when we present the witnesses in respect of MNS, we will take the Chair slowly through the process of how this price burgeoned from 38 billion and to 54 billion, and we'll be able to demonstrate why it is, at the end of the day, MNS draws a conclusion that the increase of over 15 billion was unjustifiable in the circumstances. If I then turn over to page 24, from page 24 to 26, we highlight the key findings made by MNS in this report. And as I have alluded to just before, bullet point 3, it deals significantly with the increase in the ETC from 38 billion to 54 billion. In this case, MNS notes that Mr. Gama was a signatory to the memorandum that misrepresented to the board the true reasons and extent of the increase from the initial ETC to 54 billion, the initial ETC being 38.6 billion. This was misleading because it is apparent that hedging and forex escalations were already included in the initial ETC of 38.6 billion. The hedging and the forex escalations were advanced as some of the reasons to justify the increase. At point 4, it states one of the reasons for the increase was the batch pricing. Mr. Gama attended the BADC meeting of 26 February 2014, but he failed to inform the BADC of the increase and the reasons for the increase of the ETC. At 26, we deal with the board's failure to obtain the ministerial approval of that increase in the ETC, the decision to commit Transnet to batch pricing arising out of the splitting of the award, and at page 26, we deal with other non-compliance issues such as failure to comply with the requirement for local content and the conflict of interest between, in particular, Mr. Sharma and Mr. Essa, who enjoyed a business relationship, particularly their interest in VRLS properties and VR Laser. VR Laser was a vendor at the time for Transnet, and Mr. Sharma failed to disclose this direct conflict of interest to the board at the time. Mr. Essa was contacted by China South Rail Hong Kong to provide advisory services to Transnet through his company, Tequesta, previously referred to by Mr. Pretorius, for the procurement of 359 locomotives, for which it enjoyed a success fee. Over leaflet 27, we deal with how the commission should deal with the document, with this report. We submit that, Chair, you admitted it is quite comprehensive. We point out, however, in bullet point 1 and 2, that the commission is currently undertaking an analysis of various email records and minutes and audio recordings of the BADC and the board meetings, and it's performing relevant cash flow analysis. As regards the analysis of the email records and minutes, the results thereof should be presented through the various witnesses that will appear before you. The cash flow analysis is a subject for when Transnet returns the next time to appear before you. It is not for this session, Chair. If I may then proceed to page 28, that is the report again by MNS, appointment of advisors for 1064 locomotives tender. It is dated March 2019. And the MNS mandate in this regard is reflected at page 29, which was to conduct investigations into irregularities relating to the appointment of these transaction advisors in respect of the acquisition of 1064 locomotives, and the financial transactions concluded pursuant to such appointments. We list the key findings from page 30 of that report, page 30 of our presentation, through to page 39. This is a very important report and at times complex, as Mr. Pretorius indicated. firstly, the appointment of the transaction advisors was fraught with irregularities, and that Transnet elected to use the method of confinement instead of a public tender. The reasons advanced did not substantiate a choice of confinement as a method of acquisition, because that acquisition did not meet the requirements of a confinement, which is inter alia agency. The issue with the appointment of advisors is that, firstly, a proposal was submitted by McKinsey Consortium. At the time that McKinsey submitted its proposal, Regiments was not part of that consortium. However, at the time that the LOI was being signed with Transnet, Regiments was reflected now as a part of a consortium in this tender. The problem with this was that Transnet, because Regiments did not form part of the consortium, did not have the opportunity to verify and investigate the affairs of Regiments in the decision to make this award to the McKinsey Consortium. At page 31, a further change to the consortium was effected, which was inconsistent with the policies of Transnet in this regard. Trillian was appointed to replace J.P. Morgan, and in the process of obtaining the 1 billion club loan. This was done purely on the recommendation of the CEO without going back to tender to replace J.P. Morgan, which for reasons had to leave the consortium. If we go over 32, insofar as the consortium itself is concerned, the RFP required that all tenderers submit audited financial statements. Failure to submit would result in disqualification of the bid. In the McKinsey Consortium instance, McKinsey failed to submit its financial statements and should thus have been disqualified, but that requirement was overlooked in this instance for no reasons advanced, and McKinsey became part of the consortium that was awarded the contract. At page 33, we deal with the other part of the McKinsey Consortium, which is Regiments. As I have indicated, Regiments was not originally part of the consortium, but now had become included on the eve of the signature of the LOI. The view expressed by MNS at 13 is that this constituted a misrepresentation, and states that Mr. Singh signed an agreement in January 2014 between Transnet and Regiments, setting out the updated scope of transaction advisory work that Regiments was assigned to render as a result of Nedbank no longer forming part of the McKinsey Consortium. There was never such a scope. It is an issue that was raised by Mr. Singh to justify the inclusion of Regiments in this consortium. The result of this agreement signed by Mr. Singh resulted in Regiments being entitled to a 20% performance fee, which was to be payable by Transnet. That, according to MNS, was unlawful because even on all documentation provided and the award made, Regiments was a subcontractor to McKinsey. There was no contractual nexus between Regiments and Transnet, and it could not, under the circumstances, have been entitled to any fee payable by Transnet. But that agreement bound Transnet to pay that fee, and the fee was indeed paid. There are other issues arising, which is to the extent that regiments would have been entitled to a fee, a performance fee. The contract provided that such would be kept at 9 million. But as we shall see, it was in fact paid in excess of 100 million. At page 35, we continue to deal with regiments. There will be evidence that at this juncture, before the signature of the LOI, there was an email on which Mr. Singh made certain comments, handwritten comments, and this including the fact that Regiments is not a direct contractor to Transnet. Notwithstanding his comments, Mr. Singh prepared a memorandum motivating to the then CEO, Mr. Molefe, that regiments be remunerated by Transnet on a risk-sharing model or a success fee. Why Mr. Singh did this is a matter that will be debated with the witness to the extent that they are able to clarify, or maybe Mr. Singh himself would be in a better position to assist. This misrepresentation led to regiments being paid and a fee of 79,230,000 that it was not entitled to, which MNS concludes is an amount, that amount constitutes fruitless and wasteful expenditure. The report then deals further on with the appointment of J.P. Morgan. And this appointment, MNS held was irregular on the basis that it did not comply with the policies of Transnet. At 36, we then deal with the other partner in the consortium, Trillian. As I indicated earlier, Trillian subsequently replaced J.P. Morgan in the consortium. The issue is whether or not a proper procurement process was followed in the appointment of Trillian to replace J.P. Morgan in the consortium, and the conclusion is that such an appointment was non-compliant with the Constitution and the policies of Transnet, and is thus irregular. From page 37, we tried to simplify the various payments made to members of the consortium, which are deemed to be, by MNS, are deemed to be irregular and unlawful. I indicated earlier that to the extent it may be argued that regiments would have been entitled to a fee, such was, in terms of the contract, kept at 9 million. In their report, MNS explains how the difference between 9 and 15 million rand occurs, which in their view, at the very most, is what regiments would have been entitled to receive. At 37, we indicate that in actual fact, regiments received not only more than 9 million, but more than 15 million, and that it was paid 194,240,000, including VAT. This payment led to regiments being unjustifiably enriched to the value of at least 79,230,000. And as a consequence, Transnet being impoverished thereby. At page 38, we deal with payments to Trillian, and this is a payment of 93,480,000, which was made by Transnet to Trillian, in circumstances where it is contended that Trillian did not do any work that justified payment to it for that amount or any, as the work it claimed for had already been executed by regiments. So in Trillian's case, it's not a question of overpayment, it is a pure fraudulent exercise to benefit to the tune of 93 million at the expense of Transnet in circumstances where it didn't provide services. If the chair would turn to page 39, we deal with the amounts that MNS deals with, the amounts it believes for reasons advanced in the report are recoverable by Transnet from the various beneficiaries. In this regard, it contends that Transnet must recover an amount of 79,230,000 from regiments. It must recover an amount of 189,000 from regiments, 189 million, sorry, from regiments once again, as regiments, when it received this amount, had adequately been remunerated to the extent of 15 million rand. And MNS suggests that Transnet seek to recover the payment of 93,480,000 paid to Trillian. At page 40 then, Chair, we deal with how we propose the Chair should deal with these reports. And as with the previous report, we point out that an analysis of email records, minutes, and board meeting recordings is currently being undertaken, and that the relevant cash flow analysis is being conducted. As regards the result of the analysis of the emails and minutes that witnesses will testify to soon enough, and the cash flow analysis would be at a later stage. All these this report, which is substantial, Chair, is in volumes 4, 5, 6, 7, 8, 9, and 10, and is listed as such in the index. That then deals with the acquisition of 1064 locomotives, together with the transaction advisors appointed in regard thereto. I now turn to page 41, Chair, and that deals with an acquisition of a further 95 locomotives, which is a different transaction. This is a fairly small report, comparatively speaking, and MNS found in this transaction various irregularities regarding the procurement and the award of the 95 locomotives. The commission, the investigators conclude there is no further work to be done on this transaction, and that the report should be accepted as final by you, Chair. This is then followed by the next acquisition process, which is the acquisition of the 100 locomotives, starting at your page 44. As with the 95, MNS concluded that this procurement process was fraught with irregularities, and equally so was the award. And at page 46, we extracted the key issues that MNS highlighted in regard to this transaction. The first is that the use of the confinement methodology, once again, was not in compliance with the policy, as it did not meet the requirement of urgency, standardization, and highly specialized goods as prescribed by the confinement. In the process of acquiring these locomotives, there was a decision not to acquire them if you could just bear with me, Chair. In the process of executing this acquisition, which was originally budgeted at 3.8 billion, a memorandum was prepared by the then CEO, Mr. Molefe, as recommended by Mr. Singh and Mr. Gama, that led to an increase of that budget from 3.8 to 4.4 billion, a total of 965 million, which increase MNS, based on its investigations, concluded the inflation was unjustifiable and that the factors relied upon for such an increase were not reasonable in the circumstances and could not justify such an increase. As a result of this increase, Transnet paid per locomotive 3.47 million and at times 6.2 million, which was unjustifiably increased. It concludes by holding that Messrs. Molefe, Gama, Singh, and Gianni failed in their fiduciary duties in the acquisition of these locomotives. And at 47, Chair, we indicate that the report is final, and in our view, no further work is necessary as regards that report, and the Chair may admit it as it is.
Does that mean that the legal team submits that the findings made in that report are all justified insofar as they may relate to the matters that we're investigating?
Whether the findings are justified? The only conclusion we can make at this juncture, Chair, is that the conclusions drawn by MNS are supported by evidence. And I don't know if that's what the Chair is inquiring of me.
Excuse me. Well, the focus should be whether the findings made are justified having regard to the material on which they are based.
Yes, Chair.
So that if this commission were to adopt them, it would not be subject to any criticism.
Chair, that is our preliminary view, but I say that, with your permission, Chair, with a rider, that to the extent as we work with MNS through these reports and the annexures, should we identify gaps, we shall revert, Chair, and indicate whether or not there should be any qualifications in accepting that report.
Yeah, and that should apply to all reports.
To all yes,
the idea should be for us to be able to say this report contains the following findings that can justifiably be adopted by the Commission, but these others maybe need further work, further investigation, and maybe others are just not justified.
Yes, Chair.
Yeah.
And in the case of the latter, we attempt to indicate where the gaps have been identified and what further work is required in respect of each report.
Okay.
And yes, I confirm, Chair, that insofar as 95 and 100 are concerned, the preliminary view is that they are conclusive and may at this juncture be admitted unless we revert, Chair, having identified gaps that perhaps we have not seen as yet.
Okay.
Thank you, Chair. If we then go to page 48, the Chair would have heard from Mr. Pretorius about relocation of manufacturers to Durban. MNS conducted an investigation into this relocation, and the report, relocation of OEMs, is the outcome of that investigation. At 49, we highlight MNS's mandate in this regard, which was to conduct an investigation into possible irregularities in respect of the relocation of China North Rail and Bombardier transportation from Goodesport to Durban. The Chair will recall that Mr. Pretorius indicated that the relocation concerns the costs that had to be borne by Transnet in this regard. It's necessary to determine whether such relocation was necessary and whether Transnet should appropriately be bearing that cost. This report at 50, Chair, we mark as a preliminary report. The reasons for that is that Nedbank and McKinsey have been invited to comment on the report, the preliminary report as it stands, and their comments are awaited. I would like to point out that the delay is not significant because if the Chair has regard to page 48, this report was only published in March 2019. So we expect in the fullness of time both Nedbank and McKinsey to comment and for MNS to then conclude the report, and we shall resubmit it if necessary. If they do not make comments, then MNS will tender this as a final report, Chair. I then move on to a set of reports from page 51, which we refer to as the Fundudzi reports for convenience. There are actually two separate reports. The first relates to the acquisition of 9,500 and 1064 locomotives, and the second relates to the appointment of Mackenzie, Trillian, and regiments. Before we deal with this report in detail, this is one of the reports where there is an overlap, as the Chair can see from the heading of the reports, between MNS, Fundudzi, and Waxman's, insofar as the acquisition of the locomotives are concerned. The reason for this overlap is that
I think you said 9,500 locomotives.
9,500 and 1064.
Is it not 95?
Yes, Chair.
You said 9,500.
Oh, I should 95, 100 and 1064. Sorry, I read it as if it's one number. My apologies, Chair.
Okay.
And as the Chair recalls, the acquisition of the 95 locomotives, the 100 and 1064 have already been dealt with by MNS, and the 1064 was subject of the Waxman's report. And these are the overlaps that we previously referred to. The reason for the overlap is Fundudzi was engaged by National Treasury to investigate the same transactions, whereas MNS and Waxman's had been engaged by Transnet. The issue really that arises is whether there are any conflicts between the MNS reports and the Fundudzi reports. In our assessment, there are no significant contradictions. Any that may be found could be explained by who had better access to what information. So we propose that, notwithstanding the fact that they cover the same issues, that they be admitted side by side. The second of the Fundudzi report relates to the Mackenzie, Trillian, and regiments. And these entities we have spoken about when considering the advisors for the acquisition of the 1064. For Fundudzi purposes, however, their investigation included the activities or investigation into the activities of Mackenzie, Trillian, and regiments in both Transnet and Eskom. It is thus a wider report than the MNS findings as regards these three entities. And the Fundudzi first report is captured at page 52 and 53. And at 54, we deal with Fundudzi's main findings as regards the locomotives acquisitions. In this regard, Fundudzi identifies, in particular, certain aspects that are not dealt with in as much depth in the MNS report. In particular, I would like to refer the Chair to bullet 2, which states that Mr. Molefe and Mr. Singh failed to conduct a cost-benefit analysis.
Do we have the same numbering? I see you keep on saying bullet what?
Number 2, numbering 2, yeah. Chair. I've slip of the tongue, I apologize.
Okay.
I apologize, yes. I'll call it point 2. Yes, Chair. That Mr. Molefe and Mr. Singh failed to conduct a cost-benefit analysis when a decision to change the locomotives from 19E Mitsubishi locomotives to 21E CSR locomotives was undertaken. Transnet would have saved at 1.2 billion if it had procured 100 locomotives from Mitsui at 3.188 billion rather than procuring from CSR at 4.4 billion. The Chair will recall that when dealing with this aspect in the MNS report, I pointed out that MNS found that Mr. Molefe based on a recommendation by Mr. Singh and Mr. Gama, made a proposal to the board to approve the adjustment of the budget price from 3.8 billion to 4.4 billion. This Fundudzi report gives further detail as to why such an increase was unnecessary, and based on Fundudzi, the argument was the same locomotives could have been acquired from Mitsui at about 1.2 billion less. There will be a witness who will speak at length, Chair, on the 19E locomotives and the 21E locomotives. It is not necessary at this juncture to go into this detail. One of the important aspects as well is at point 5, which reflects that Transnet board failed to notify the shareholder, as it was in law bound to, of acquisitions and disposals above 2 billion before it concluded the contract with CSR. And this is a requirement of the shareholder compact. And in contravention thereof, the Transnet board concluded this contract with CSR without informing the shareholder. At page 55, Chair, we briefly deal with how we suggest this report be dealt with by the Commission, and we indicate that it is a final report, again with just a qualifier at points 1 and 2, which is that the analysis of emails, records, and minutes of the board and the BADC is currently being conducted by the Commission. Equally so are the relevant cash flow analyses, and that will be dealt with in due course. From page 56, before I go to 56, Chair, if I may just for the record point out that the Fundudzi report on the acquisition of 95, 100 and 1064 locomotives are in your volume 14. And at volume 15, it contains 2 documents, the first of which is the second Fundudzi report, which is the appointment of Mackenzie regiments and Trillian. At page 57, we set out the mandate. Most importantly, Chair, at page 58, I was hoping it's catching up with me, my slide presenter. Thank you.
Yeah.
Page 58 indicates that the Fundudzi report, insofar as those 3 entities are concerned, is much, much broader than the MNS investigation. It spans a longer period, which is a period from 2012 to 2016, and deals with at least 8 separate transactions, all of which have been investigated by Fundudzi and findings made and recommendations made in respect thereto. So the overlap with MNS would be about the advisory services for the 1064 locomotives and the SWAT and SWAT 2. The rest, MNS did not investigate at all. So insofar as the Chair would like to hear more about those transactions, one would have to have regard to the Fundudzi report. And once again, there will be witnesses who will table these reports formally and deal with their detail. At 59, page 59, Chair, Fundudzi deals with various irregular payments made to Mackenzie regiments and Trillian. And these included payments at 6 of what is referred to as out-of-pocket expenses in circumstances where the 3 entities did not submit any supporting documentation to substantiate entitlement to the amounts reflected in the invoice. The 3 Mackenzie regiments and Trillian were paid 1.5 billion during the period 2012 to 2016 in respect of the contracts awarded to them through confinement. Yet again, Chair, it's a question of the process that was employed by Transnet to get these entities on board, this process of confinement, which was not only irregular but was unlawful as the circumstances of acquisition did not meet the requirement for confinement. Most importantly, Chair, at 9, Fundudzi found that Mr. Ramusibudi misrepresented that Trillian assisted Transnet to negotiate with Nedbank, Bank of China, ABSA, and Lipfin in the memorandum dated 17 September 2015. This is in respect of the club loan that is dealt with in the MNS report. And Fundudzi concluded that this misrepresentation, it is this misrepresentation that resulted in Transnet making a regular payment of 93,480,000 to Trillian Asset Management. The Chair will recall that in Mr. Pretorius' presentation, I think Mr. Ramusibudi at the time was a senior executive within Transnet, I think within the Treasury Department. And such a finding is, of course, concerning. At 60 then, Chair, once again, we deal with our recommendations, and we suggest that the report may be placed before you with the proviso, of course, that we shall revert with the findings regarding the current analysis being undertaken of audio recordings and minutes and the cash flow analysis. The second document in your volume 15 is what appears from your page 61, Chair. It is a report that was commissioned by Mr. Tokyo Sukhwale, then the chairperson of Trillian Capital Partners, into allegations with regard to the Trillian group of companies and related matters. This report was prepared, the investigation was conducted and report prepared by Advocate Butlender SC. The mandate of Advocate Butlender appears at 62. And in the main, he was required to investigate the allegation that Trillian invoiced some SOEs for work which was not done and was paid or invoiced without contracts. He was secondly to determine the role or impact, if any, of members of the Gupta family and persons associated with them on the activities of Trillian. The opening caveat by Advocate Butlender is key, Chair, to understand the detail, or in some instances, the lack of detail of his report. And it states, I read for the record, quote, "The management of Trillian have obstructed this investigation. The obvious question is why they have done so. The only conclusion I can reach is that the questions which I raised and my request for documents and information led them to conclude that if they compiled with the undertaking they had given, information would be revealed which would be embarrassing to them. I can think of no other reason. I expect that Trillian will say that some of the factual information in this report is incorrect or incomplete. If that is so, it is because Trillian refused to cooperate with the inquiry. This investigation is still incomplete, and he said he could have spent more time, except that at the time it had become clear to him that the inquiry would not reach a satisfactory conclusion." It is with that qualifier then, Chair, this report must be dealt with.
I think we have referred earlier on, there was a reference to an incomplete report. If a report is incomplete, how much value is there in including it here?
We have found that it has got two values. Firstly, it's an investigation that has been undertaken. Absence or lack of access to certain documentation, which is listed, made it impossible for Advocate Butlender to draw a conclusion. He has, however, given detail of the documents required to substantiate his preliminary findings, and we, as the Commission, are able to access those documents from Transnet. So for an incomplete investigation, and I think we deal with this particular yes, report at page 68 and suggest how it must be dealt with. And we say that at this stage, these are allegations which would need to be substantiated and confirmed by the Commission. But there are allegations that are useful to the work of the Commission.
Yeah, but shouldn't you just note the documentation to which he refers, and then the Commission does its own investigation, because he's not drawing any final conclusions. So what's the use of including the report for purposes of this Commission?
Chair, we
can't say much about findings that are not conclusive, that are not final conclusions.
Chair, if I may give an example, at page 65 on to 68, Mr. Butlender deals with a payment of an invoice of 10 million rand. He, however, finds a claim, and he needs for us to check whether that was paid for same services for, again, 10 million rand. The question he poses is whether or not this constitutes two payments for the same service provided. And because of that important exercise that he has conducted, we thought it appropriate to bring it to your attention, but we state as we do so that the report, we find it to constitute useful background information and intelligence, but is subject to the limitations that he could not draw any definitive findings.
Yeah, I'm not sure that it's very useful to include it here. It may be that all that should be done is to note certain things that he has said, and then the investigators of the Commission could then investigate those, and not to include the whole report. So you may have to reflect on the question whether it really serves much purpose to include it here.
We will do so, and Chair, it may very well be, because we also characterize it as useful background and intelligence, we would uplift it, and we will make the appropriate amendments to the index and to your file, Chair.
So it might be useful for the investigators to follow up certain things as opposed to including it here.
That is already underway, Chair.
Okay.
Yes, and we shall revert, therefore, Chair, as regards the issues arising here from and the results of the investigations.
Yeah.
But in the meantime, it shall be uplifted and it will not form part of the Transnet documents. I would then, Chair, then turn to the next report, which is at page 69. And this is to be found in your volume 16. This is a report by Qhubeka, that's Qhubeka, UBEC as capital U, capital B, capital A, capital C.
If that is Zulu, it would be pronounced as Qhubeka.
Qhubeka.
If it is Zulu, I don't know if it is Zulu, but it does look Zulu.
Chair, neither do I know if it is Zulu, but I'll go with the Chair's suggestion, Qhubeka.
Okay.
And I did spell it, it's Qhubeka for purposes of the transcribers. And this is the report of investigation into the Transnet National Ports Authority, investigation into the Neotel transaction. At page 70, we provide a summary of the issues pertaining to this transaction. This was in large part a transaction for the acquisition of CCTV and related equipment for the Ports Authority. The issues that in the main arise from this report is that Transnet paid an excessive price for what was delivered. It contracted at 150,000 rand per unit provided, And it has since been established that the equipment provided ranges in price from between $4,500 and $9,000. On the second point, it deals with the quality of video recorders provided and concludes that these were a cheaper product than that contracted for. There is a question of the guarantee provided by Neotel. Neotel appears to have provided a 3-year guarantee, but the original supplier of the equipment to Neotel, I don't know if it is NICE or NICE, I'll settle for NICE. The documents indicated that it could only provide a guarantee for 2 years. The question then is, how does Neotel provide a 3-year guarantee in those circumstances? The last key issue is at point 4, which is that Neotel itself, as a supplier of this equipment, is not a registered security services provider in terms of the Private Security Industry Regulation Authority, Act 56 of 2001. The investigators of this transaction concluded that they are in law required to be registered as security services providers before they can be engaged to provide these services. The witnesses will testify in this regard, and it's beyond doubt that Neotel did not satisfy the requirements of the Act in this regard. At 72, we then, Chair, deal with our recommendation, and we say, although it is a final report by Kubeka and UBEC, further procedures must still be performed or undertaken. And one of those is to conduct an assessment whether the technical specifications were appropriately addressed by Neotel in delivery on this contract, and to perform a physical inspection of all the equipment, the recorders on site, to dispute the version that has been put forward by NICE in relation to the video recorders. So this is one of those reports that are inconclusive, Chair. The suggestions and recommendations made here for extra procedures to be conducted relate in large part to Transnet. These are not issues for the Commission to undertake. So we suggest that the report be preliminarily accepted, and Transnet, in the fullness of time, to report back to the Chair on whether they have implemented these recommendations and what their further investigations have found. I turn then, Chair, to page 73. And page 73 deals with, is a report by Ligwa, L-I-G-W-A. And this was an investigation into allegations of irregularities relating to the network transition program and asset buyback. There are two transactions, there are two issues that the report looks into, Chair. It is, on the one hand, the network transition program, and a separate issue is the asset buyback by Transnet from Neotel. Now, insofar as the network transition program is concerned, Ligwa made these following conclusions, and these are reflected at page 75. Sorry, my apologies, Chair, these are not conclusions, this is the mandate. And Ligwa's mandate at 2 was to determine which services were included as part of the transition of services budgeted for at 225, and amongst
Well,
others,
the mandate is at 74 and not 75, isn't it? 75?
it's at 74, and
And, yeah, okay.
overleaf, the heading is not correct to say that it's key findings. The key findings are overleaf at 76. The issues listed at
So-
75
So, yes,
are the, Chair, if I may say 74, I said there are two issues that LIGO was to investigate. As regards the network transition program, the specific issues under that program it was to investigate are listed in 75.
so the heading key findings
It's a wrong
include-
heading.
should be crossed out.
Should be crossed out, Chair, because this was the specific mandate in respect of the network transition program.
Okay,
My apologies there, Chair.
maybe what you can do is provide a corrected page 75 in
Will
due
do, Chair.
course, yeah.
The key issues here in the network transition program, besides a concern that a transition agreement did not exist in the first place between Transnet and Neotel, is that the 225 million contracted for the network transition program did not detail the actual services that were to be provided for payment of that amount. And at point 5, a further issue that LIGO looked at was following the payment of 225, a further claim by Neotel of payment of 500 million in respect of the same services. These were the key issues that LIGO had to investigate. Its findings start at page 76, and the key ones I'll refer to, and this time, Chair, I'll be correct, under 2 is bullet point, second bullet point. And LIGO,
Yes, you are correct this time.
thank you, Chair. LIGO notes in its report that Neotel had submitted a proposal for the services, and it had quoted an amount of 132 million, which amount was split between 3 different services. If the Chair then has regard to bullet point 4, the last on the page, as notwithstanding that Neotel had bid for the works and costed them at 132 million, Neotel and Transnet actually concluded a contract for 225 million. That contract did not allocate or did not provide any breakdown of services and did not allocate any cost to any particular service tower. Chair will recall at bullet point 2, the 132 million is as,
I'm sorry. With regard to bullet point 4,
yes.
I thought you made a statement that made me have a look here. I thought you were saying that although X amount was, the bid amount was X amount, another amount was awarded, but they seem to be the same figures.
No, the bid amount is in bullet point 2. The last sentence of bullet point 2. Neotel's proposal amounted to 132 million
Yes,
and was split between 3 different services.
yes.
Bullet point 4 says the total fee amounted to 255 million excluding VAT. And that 255 million was not broken down, and neither was it allocated between the various service towers, the 3 service towers.
Is the suggestion that the bid amount was 132 million,
Yes, Chair.
but ultimately the amount awarded was 225 million.
The contracted for amount was 225 million.
Oh, I think the way it's formulated, it doesn't make that clear.
It doesn't make that
but
point
when
clear.
you were
Yes,
when you
Chair.
were dealing with it, you did make it clear, except that I could see that the amounts looked the same on bullet point 4, and therefore what you were saying didn't seem to make sense.
Indeed, Chair.
So you might have to
We'll revisit
reformulate
page.
here to say, to make the although in your statement make sense.
Indeed, Chair.
Okay.
Yeah, but then the Chair appreciates the difficulty with this. And the difficulty with this transaction is that the increase in cost is not explained. There is no documentation to explain it. All that is available is a contract for 225 million. And this point is made at page.
So maybe therefore this page also, you might replace it with one that has an amendment of what we have just talked about.
I have made a note of it, and in fact, Chair, if I may refer you to page 77, we would dovetail it with what's contained in 77, which states, first bullet point, Legal have not received any explanation as to the difference between the proposed amount being 132 million and the amount included in the MSA being 225 million.
Yeah.
Second bullet point at 77, it is evident that the 225 million was paid by Transnet to Neotel without Transnet knowing what services were included in this payment. The point I'm making is to take those two pages, reword, and
Yeah.
so that it is clear what the issues are arising from this legal report.
Yeah, because I think what you were saying, which is not clear here, was you were contrasting the amount that was in the bid documents.
Yes.
And the amount that was actually awarded.
Indeed, Chair.
And highlighting the difference.
That's what intended to do, Chair. We shall attend to it, Chair, and we will attend to your file as well. At page 78, we have extracted the main issues from the legal report in regard to this transaction, and now it confines itself to the 225 million rand. At bullet point 2, we reflect what the report found, that the 225 million was intended as a once-off fee and was payable within 7 days of the effective date being contained in the contract. So in effect, the contract provided for an advance payment of 225 million, excluding VAT. And this would be a full payment of the contract amount prior to any services being rendered. In the last bullet point, the point is made that Neotel issued invoice number 70074 for an amount of 225 million, VAT exclusive, on 9 December 2014. And the date of that invoice precedes the date of signature of the MSA by 5 days. Overleaf at page 79, bullet point 2. On that invoice of 9 December 2014, on 17 December 2014 at 79 bullet point 2, Mr. Singh approved payment of this invoice. And that invoice at bullet point 3 at page 79 was paid in full, 225 million excluding VAT, on the 23rd of October 2014.
Your headings, key findings include in some of those pages, are they correct?
Yes, Chair.
The reason why I'm asking that is because in a number of pages where you have that heading, immediately under it, you have like at page 77 under 2, determine which services were included, which seems to relate to the mandate.
No, Chair, at page 75, we've corrected and we've removed the the heading key findings include, because at page 75.
At 75?
Only at 75.
Okay,
because that lists the mandate in respect of the network transition program.
Okay, no, we did that.
Further on, the rest then deals with key findings.
Yeah.
And if the chair will have regard, for instance, to 76, 76 starts with number 2, determine which services were included. And what the page does is to each time
I think I know what you are trying to do, but I don't think I think you did it in a way that's causing confusion. I think you should have said something like, in relation to the determination, blah 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 blah. Shouldn't you have done that? In relation to the determination of which services were included, or something like that. Then you say these were the findings made.
The specific mandates were used as headings.
Yeah,
I understand.
what you are doing, you are repeating
we can reword
the relevant part of the mandate, and
yes.
then you are setting out the findings. But I think that would make it clear. So in relation to that part of the mandate, these were the findings.
And the findings are the bullet points.
So then maybe all the relevant pages you could do that. Yeah.
The same would apply to 77, 78. And 79.
Yeah, you can just go through
and go
them.
on.
And
we will make those changes so that it is clear
Yeah.
that each page deals with a different exercise,
Yes,
a separate
yes.
exercise,
Yeah.
and what conclusions are drawn therefrom.
Yeah, yeah.
Yes.
Or if you don't put it like that, another way of doing it would be to say immediately after 2, for example, in 76,
Yes, Chair?
mandate, ...
Okay.
and then you put determine, but then you put findings immediately below that, so that it's clear these are the findings that relate to this mandate, this part of the mandate.
We'll consider doing that, Chair, and
whichever you prefer.
we shall attend to your file accordingly.
Yeah.
In dealing with the payment of 225 from page 76, I don't know if the chair followed me because I did not highlight all the points.
Yeah.
I more or less, jumped to the key points.
No, that's fine. You might not need to highlight all of them.
Need I go through the issue?
You can only highlight what you think is important.
At 78, Ligwa's findings, I'll start with bullet point 2. And the issue there is that the MSA concluded between Transnet and Neotel provided for payment of 225 million excluding VAT to Neotel. And at bullet point 4, the point is made that that payment was due in full prior to any services being delivered by Neotel. The last bullet point at 78 points out that on 9 December 2014, Neotel did issue an invoice of 225 million against Transnet for what it called mobilization fees. The date of this invoice is important because it is exactly 5 days before Transnet and Neotel signed the MSA agreement. Overleaf at 79, I then have regard to bullet point 2, which states that that invoice for advance payment, dated 9th of December, was approved by Mr. Singh on 17 December 2014. And this was still again 2 days before the contract was concluded. And at bullet point 3, the issue there is that the invoice was honored in full on 23rd December 2014, following approval by Mr. Singh. Notwithstanding at page 80, Chair, that the full amount of 200, notwithstanding the fact that the full amount of 225 million was paid for a contract that was to be completed in 12 months, as indicated at the second bullet point at page 80, as at the 8th of September 2015, and the Chair remembers that the award comes from December 2014, only 38% of that contract had been executed. And at that point, it was supposed to be at 43% if it was to meet its completion date. The issue that arises from that is, and I will just remind the Chair that this is September 2018, the report, is it needs to be established whether or not that transaction was completed in full. Chair, it is being brought to my attention that it is 1 o'clock. I have got very little left to go through. If we were to break for lunch, Chair, I probably would take maximum half an hour after lunch. I would propose that perhaps I deal with the remainder of the report now and finish it.
Are you not going to have a witness ready to take the witness stand when we are done with this?
Chair, if
Looks
I may
like there
just
will be enough time.
look behind me and the next witness for Transnet is the chair of Transnet, and it's a question of his availability. Today, he's scheduled to appear before you, Chair, tomorrow.
Is he not here? He is here. He is here and he has raised his hand. so we can continue.
I'm advised that all three notices of persons implicated by Mr. Molefe provide the date of the 7th of May. So all those implicated know to come tomorrow and not today. It might be something the Chair might consider. May I suggest differently, Chair? We may break for lunch and maybe we confer and see what...
Yeah, let's break for lunch and then when we come back, I'll hear what you have to say.
Yes, Chair.
We'll take the lunch adjournment and resume at 2. We adjourn.
Thank you, Chair.